So to defeat that presumption, one states, I do not recognize you. I do not acknowledge you, and in no way have I appointed you my agent. But there's a second presumption. Remember I said that agents are appointed by letters patent or warrant. So the second presumption is that they have been granted by letters patent some agency powers from a higher power. So we would follow, unless you can produce here now the warrant or patent under which you are claiming agency authority, I refuse to recognize or acknowledge that you have any agency or agent jurisdiction. And so now we move on to the fiduciary. But as you are appointed into a fiduciary position, I hereby bind you to your oath and appoint you fiduciary or call on your fiduciary obligations to hear this matter. That's a bit of a mouthful. We'll go through it again. I do not recognize you. I do not acknowledge you. In no way have I appointed you my agent. And unless you can produce for me this moment the warrant or patent upon which you claim authority, and I might see to whom the executor who makes that authority and by what claim the executor makes that authority, I do not recognize you or do not acknowledge you in any way as an agent having jurisdiction. But as you're an elected official, I bind you to your oath and I call on you to serve in your fiduciary capacities. Now, there isn't a judge, or it could be a county recorder, or it could be a prosecutor, it could be any of those roles, because they're all doing this double game. They've got agency powers and they've got fiduciary powers. Anyone in those positions will know clearly what you've done. The game is up. They know that. Or a policeman, or a sheriff, or a bailiff on your property. They know. But as we started tonight, I want to come back to it. This is the difference between UCADIA and people who take this information and steal it or claim it as their own. Because here we're trying to explain the provenance, the logic, the why. Why is this important? Why does this work? Why are they getting away with it, as opposed to simply blindly point and click? I hope when you listen to this tape again, or those who are listening tonight, re-listen later, that you will hear this again and you will see how important this is. And you've got to extinguish any presumption of agency before you can get to fiduciary. Okay. Once again, we run low on time, so I'm going to run a little bit over time in the chat. But I want to get to birth certificate. I want to get promissory note. I want to talk about October 31st, and then we'll wrap up. I want to raise birth certificate because we've had these discussions of birth certificate before. We know that the birth certificate is an extract. It's an extract from the records on their system, and so it is a certificate of title. It is that. And it's why there's been so much confusion in terms of what's going on in terms of what is the birth certificate representing. Now, while you remain a pauper, while you are under the presumption of intestate, while you remain effectively a slave, there is nothing you can do effectively with your birth certificate. It's a valuable token, absolutely, but you do not have original title over it. However, all that changes if you were to follow what we have been discussing in terms of will and testament and being competent, understanding the reasons why, in terms of the recording of your will and testament, in terms of recording the appointment of the Office of General Executive. Once you have proof on the public record, on the estate record in their system, that you are the occupant of the Office of General Executive, then one can go and get an apostilled birth certificate. An apostilled birth certificate. And then with that, one can go and have that recorded as the property of the estate. Recorded as the property of the estate. Now, why will this work? And what does that mean? It turns out that under the bankruptcy laws, we've been approaching the argument of birth certificate in many respects from the wrong angle. What they are doing every 10 years is that they are effectively reconstituting into a new corporation the slave rolls and the recording of the slaves as collateral. That's a census. This is the core property that remains within the corporation every 10 years. So it's a corporation that is claiming you as property, not merely the estate. Well, that changes everything. I mean, if it was merely the estate that was claiming you as property, okay, I could see that there would be difficulty in this. But given it's a corporation that is being folded and a new one being started every 10 years and recorded with the SEC, then it is fair game. It is fair game for our estate to claim this property and not some corporation, this temporary trust created in bankruptcy, to claim your name, your body, as their property. So we can take the apostille birth certificate and we can have it properly recorded so that we obtain for ourselves a proper certificate of title, certificate of acknowledgement of the recording of the res into our estate. And they cannot deny that it is rightful property of the estate. They can argue about all the hidden trusts. And a general executor does not make presumptions. I don't know how much money is in those trusts. I don't know what's going on with those trusts. But I do know that that corporation is claiming the slave name as property and collateral every 10 years. So we can get that. We can have that recorded rightfully as property of the estate to which you are the occupant of the office of General Executor. Now, once you get that birth certificate recorded and you've got proper title to that property, you now have very valuable property in your estate, and rightly so. And as General Executor, you can now move forward onto the next phase. And I'll mention this before we move on to October 31st. I'll mention this, and I caution you, please, not to rush forward on your own things, but to think about the significance of this. Once you have the birth certificate recorded as the rightful property of the estate, and you are in the office of General Executor, we know that they still will not trace and perform the tracing on the estate. They will not start to own up. Well, that's fine. If they won't, then you have property against which you can issue a promissory note. And guess who has to endorse that when you give notice and instruction to them to commence the tracing? They can argue the tracing may take years, and indeed it may take years. But you have things to do. So in the meantime, they can endorse the promissory note against the estate, for which will be deposited and drawn down in a bank account for the estate. And they can ensure that the bank will allow the account to be established. But that promissory note can be deposited in the bank. They can endorse it while the tracing is taking place. And there is a legitimate way to get a promissory note endorsed and collateral and actioned. So I bring that to you, that there is remedy. There is more and more remedy in their system as their system falls apart, as their system breaks down. But UCADIA is not about simply making money. In fact, it's never been about making money. I wish it was sometimes, because I have certainly used up everything I've ever owned towards UCADIA. I've made nothing out of this. It is, however, about restoring the law. And October the 31st is a very, very important date, a key date, in terms of continuation of restoring the law. So for the remaining 10 to 15 minutes, let me talk about what is proposed for October the 31st and the bigger picture of what we're heading towards, and share with you some of the discussions on that. I mentioned last week that I wanted to have something ready to share with you tonight on what is to go out on October the 31st. And what we're saying is something that all of us can utilize. Hopefully some may find a way to publish if they've got some money to get it published. Some may go up to their local church and have it posted on the church board. Some may feel brave enough and willing enough to go to court and notice board or recorder's notice board and other places of public notice and have it recorded. Some may even choose to have it posted to officials to have it sent as a form of public notice, so that as many people can hear about the October the 31st notice as the restoration of law, as the collapsing of the Roman cult, the collapsing of their claims against us, where they claim we are their chattel, we are their property. Now, the date for October 31st is significant because it is the date and anniversary of Martin Luther, almost 500 years ago, where he was supposed to have nailed to the door of the All Saints Church his 95 Thesis against indulgences, which we've now said still continue. But that act is supposed to have heralded the creation of the Reformation. If one believes in the King James Bible, then you've got to thank Martin Luther and what we're about to recreate as the event. If it didn't happen, then that document wouldn't have existed. If you are a Protestant, if you are Church of England, if you're a Lutheran, if you're a Baptist, if you're any of these groups that looks to some other connection to your faith other than through Rome, then Martin Luther is the catalyst. And what we're talking about is a recreation of an event 500 years ago. That's how long it's been, 500 years almost, that we're recreating. Well, I said I was going to have something ready, and we don't yet have it ready, but I want to share to you what it is being proposed so you'll understand why it's going to take just a couple of more days to get ready. What's being proposed is that the instrument to be published is called Ritus Verum. Ritus Verum, or in English, the 144 Truths. Now, this title will be a document that still enables the collapsing of the third and final trust of the Roman cult, but it is chosen in honor of Martin Luther. It is chosen in honor of the whole concept of the protest movement. It is chosen in honor of the founders of all these great countries. It is chosen in honor for the documents and what we believe they mean, whether they are or they aren't, when we talk about the Declaration of Independence. It is chosen in honor of our grandparents and our ancestors and our beliefs and the things we claim to others that we are, whether we are or we aren't. If we are true in any way, if we're not a double agent, if we're not a disinfo agent, if we're not crippled by our ego, if we're not someone who just comes on to make mischief, if we truly are someone who stands for anything, then what this document needs to be is a matter of truth. A statement of truth. A statement of what the hell do we believe in. A statement that at least honors the intentions and the image and the history of Martin Luther. 144 truths. So it's going to take a few more days just to pull those off. Now, where are they coming from? They are coming from the canons. The canons, in many respects, provide to us the bedrock of the truths. It's a matter of collecting